Well, hello, everybody. Yes, another edition of Zoom, Landlord, Tenant, Talk Radio. It is June 15th, 2024. And in case you guys were curious, the name of the song was Grenade by the group Bruno Mars. Before we launch into the topic of the day, I did want to wish happy Father's Day for all the fathers out there listening. It is tough to raise children, and you know what? I think we all do a really good job. So enjoy your day tomorrow. Happy Father's Day. I know I'll be enjoying that with my children and my wife. Today, I wanted to talk about that it's time to increase the rents. Ladies and gentlemen, I've said in these broadcasts and in any of the seminars that I do that rent control is a cancer, and it keeps growing and growing. The list of cities that have instituted rent control just in Southern California is absurd. And the only way that you can protect yourself is by having your rents at market value. If you can get your rents up to market value, then they really can't hurt you. And what that means is that any time you have the opportunity to raise rents, you must do it. This is your business. You must do it. Do not feel sorry for tenants. Again, as I always say, if you want to be charitable, give to your children, give to close family members, and give to the City of Hope. That's about it, though you can't switch the last one for your own charity. But if you're gonna be in business of being an income property owner, then you have to treat it like a business. If you have the right to raise the rent to market level, you need to do so. So we have some time periods coming up now where the different municipalities are allowing for rent increases. I do want to talk about what the percentages are that you can legally raise the rent. But first, I want to talk about the issue of how to prepare a rent increase. And it's pretty simple. I'm going to share my screen with you right now. And if you do go to my website, which is evict123.com, you're going to get to this website, which you probably know because you join the meetings by going to this website. And I have a form here called Free Landlord Forms. So if you need a rent increase notice, just click on this. And then you're going to come down a little bit to right there. This is the rent increase notice. It's a pretty simple one. Let's see if I can make this a little bigger for you guys. And as you can see, you can fill this in. This is a fillable form on my website, where you just would fill in the person's name. Then you fill in the address, and you're saying that the monthly rent shall increase to the sum of, and then effective what day, you date it, and you can either type your name there. There's no reason to sign it. And that is basically how you prepare a change of terms of tenancy to increase the rent. Now, let's stop sharing here. If you are raising the rent 10% or less, which would obviously be the case in rent controlled areas, then that's going to be a 30-day notice, 30 days. If you are raising the rent more than 10%, then that's a 90-day notice. There is no such a thing in the state of California as a 60-day notice to raise the rent. It's either 30 or it's 90, okay? Now, how do you serve that rent increase notice? Well, number one, it either has to be at least 30 days in advance or 90 days in advance. So one way to serve it would be to merely hand it to the tenant, walk over to the door and hand it to the tenant. And if in fact the tenant is there, you can just hand it to them. The other approved method, where you don't have to get out and go to the tenant's door, would be just to mail it. So it's perfectly permissible under the code to prepare a 30 or a 90-day rent increase notice and to mail it to your tenant. However, it comes up with the issue of a 5-day mailing rule. So if you're going to mail it, you got to add an additional 5 days. So for example, if you wanted to increase the rent come August 1st with a 30-day notice, don't wait to July 1st. You're going to need to mail that out on June 25th. By mailing it out on June 25th, you've allowed for the additional 5-day mailing rule. Okay. Same thing is true with a 90-day notice. Right now, if you were going to increase the rent, we'll get into how you can increase it more than 10%, but you would mail it out at least by June 25th, and 90 days, you would count, that would be July, August, September. So that would be effective as of October 1st, 2024. Now, the issue is now that we know how to fill out a notice, and we know whether we've got to give 30 days or 90 days plus potentially that 5-day mailing rule. The issue is, how much can we raise the rent? Well, number one, if your property is not subject to any rent control statute, be it a local statute or a statewide statute, then you can raise it to market level. You can go up to whatever you like. So if the rent's $2,500 and you realize that this house legitimately would go for $4,000, you can do a $1,500 rent increase, which would obviously be much higher than 10%. Now, what types of properties are not subject to any rent control? That's very simple. And that is single-family homes, townhomes, condominiums. Those are all not subject to any statewide rent control or any local rent control. You can raise the rent as much as you like, okay? Also, if your property was built within the last 15 years, again, under the statewide rent control, you are not subject to that rent limitation. So go out, serve your notices. If you have properties, ladies and gentlemen, that are below market and you have the right, it's an unlimited rent increase, I would tell you to get your notices ready right now and send it out today, because we don't know what the politicians are going to be doing to us, but we can guess it's not going to be good. They are going to try to take us down anytime, anywhere that they possibly can. So on that basis, if you can raise the rent, then do so. Now, what if your property is subject to statewide rent control? How much can you raise the rent? Well, first of all, you have to understand what properties are subject to statewide rent control. And the first answer to that is, if your property is not subject to a local jurisdiction of rent control, then it potentially could be under the statewide rent control. So for example, a single family home in Burbank, California, where my office is. Burbank doesn't have rent control, at least it doesn't have it as of now. So that would not be subject to statewide rent control. Townhomes are not, Section 8 is not, and also condominiums are not. So, but if your property is, let's pretend I have a triplex in Burbank. Now I'm subject to statewide rent control. Come August 1st, 2024, you're allowed to raise your rent, if you haven't raised it in the last year, 8.9%. That's the newest figure. 8.9% for Orange County and LA County. There are some Riverside and San Diego and San Bernardino do have, it's a little bit more on that. I'll go into that. If you go to my website, you'll be able to find out those figures. But for the LA County area and Orange County area, it's 8.9%, and that could be effective as of August 1st. So right now, if you're going to serve a notice and with the 5-day mailing rule, you would serve it right now and raise those rents, assuming you haven't raised the rents within the last 1 year period. Okay. Now, What if your property is subject to RSO for the city of Los Angeles? RSO standing for the Rent Stabilization Ordinance. If your property is subject to the Rent Stabilization Ordinance, they have approved come July 1st, that's just in a few days from now, a 4% rent increase. So if your property is under RSO and you haven't raised the rent in 1 year, shame on you. But if you have not, then as of July 1st, you are allowed to serve a notice. Well, right now you can't serve a notice to be effective July 1st. You've already missed your window of opportunity. So this would be for August 1st, you'd be able to raise the rent 4%. That is, so the anniversary of when you last raised the rent. So if you did it in February, as many landlords did, as I know I did, on one property that I have in Studio City, then you'd have to wait until that following anniversary date. And then it's going to be 4%, and that is effective as of July 1st. If your property, and we'll finish this quickly, if your property is subject to unincorporated areas of LA County, that too you're entitled to a 4% rent increase that is extended through December 31st, 2024. If you have property subject to unincorporated areas of LA County, you need to immediately raise that rent, and the top value that you can raise your rent is 4%. But don't forget, if you've got a single family home or a townhouse or a condominium, or your property was built within the last 15 years, you don't have rent limitations. So get out your handy dandy 90-day notice and either hand it to them or mail it to them. Again, you must keep your rents up. If you don't, this is only going to harm you, and it's only going to get worse for you. That being said, that was my topic of the day. Let's move on to, we're going to take some callers now, but we all know the ground rules. And what is that? That is everything I'm talking about today, or the opinions expressed by our meeting members, is for informational purposes only. It is not a substitute for legal advice. If you do want to talk to me, feel free by electronically raising your hand. You'll find it in the toolbar at the bottom of your Zoom or on the side of your Zoom meeting credentials. And last but not least, if you've got a case with my law firm, I love talking to you about it, but this meeting is just for general questions only. Please reserve those questions for calling me at the office. And I think on, what was it, Thursday, I think we had a record day. I think we took over 225 calls. So with that being said, I am going to open it up, and I see a familiar face. I'm going to ask Jim to unmute yourself, please.
Hi, Dennis. How you doing?
I am good, sir.
It's funny that this is your topic, because this is my question. I wanted to ask you, what do you think of this concept? I was preparing a 90-day notice. I am not subject to AB 1482, no rent control, single-family homes. I'm going to raise the rent probably over 17% to a pretty high, little above market rate. However, in this change of notice, I'm putting down that they're getting a 10% discount on the rent for doing the yard work. And that brings it down to the current amount they are paying. That's my strategy to raise the rent.
I think it's a bad idea.
Okay, why is that?
Anytime you're asking a tenant to do something, they're never going to do it. They're never going to clean the pool. They're never going to do the gardening. It's going to look miserable. If you want a gardener, or you want your lawn maintained, get a gardener. You want your pool maintained, get a pool man, and just build that into the rent. I think it's a horrible idea. I've seen this time and time again. The tenant doesn't do it, and then what are you going to do? You already gave them the discount. You're going to take away the discount. It's crazy. So Jim, listen to the old man. You want a gardener? Get one. Pool man? Get one. And don't ever let a tenant do their own repairs. I don't care that the guy's a certified plumber. If something goes wrong with the plumbing, get your own plumber in there.
Right. Okay. Thank you, Dennis.
All right. You take care. Stacy C., I'm going to ask you to unmute yourself. Stacy C.
Hi, first time user. Thank you so much. Heard about you. I've got a tenant who is in a bedroom that she was renting from us in a RSO building. She was a best friend. She moved in 8 years ago at $1,500 a month. We'd never raised her rent for 8 years. She was in a bad situation. We never gave her a lease. We now know she's a tenant. She is now suing us, claiming that our unit is illegal and she wants $655,000.
Only 655.
655.
655,000. I just want to ask you one question before we move on, is how's that friendship going?
Don't ask. Somebody wants to go over and break her legs, but I know I'm being
Okay,
recorded.
are you in an apartment or a single family home?
It is a duplex in Los Angeles.
Okay, and she lives with you in the duplex.
She lives in the downstairs unit that is 3 bedrooms, 3 bathrooms. And she moved in years ago to help take care of my parents who were living downstairs. There is a doorway that shuts up to the master bedroom. And so she lives up in the master bedroom. It has its own separate entrance as well. So she's got a
Okay,
kind
but
of a
other
place of her
than
own.
where she lives and you live, is there another unit as well?
No, it's just 2 units.
Okay, so there's 2 units and she's in a legal unit on the bottom.
We don't know. She's claiming, her attorney is claiming that it's an illegal unit. That's why she's suing us for $655,000. She wants all of her rent back for 8 years plus damages,
Okay,
times
well,
3 plus damages.
Number one, she's out of her mind. And there is no basis in law, even if it was an illegal unit, which I don't think it is, but you'd have to call the office and I can look that up. It's probably listed as a single family residence. If we weren't on the air now with a bunch of people listening to us, I'd ask you to give me the address. So call me at the office and I can look that up. But whether it's illegal or legal, number one, there is no basis of giving back rent paid. There's nothing in the law. Have they actually filed a lawsuit?
Yes, we
Okay.
were served a few days ago.
Okay, so what we want to do is, number one, you probably want to call me. I can go over whether in fact that's a legal unit or not, based on the fact that there is a doorway between the upstairs and the downstairs and not a sealed off wall, which means that even if the doorway is locked, if I walk into your unit, I could get to her unit without walking outside, I presume.
Yes, although it appears that she might have sealed it off.
Well, I don't care whether she sealed it off, but if you can see a door, correct?
There's a door.
Okay, so then that means it's not a wall. The wall is a bad one.
No, there's no wall. It's a door,
Okay,
but
so
yes, we haven't been
that's it.
inside,
So
but we
we'll
know that
make
it's sealed
short
off.
shrift of this. And by the way, from now on, the reason why you're going to evict her is because you don't want to have any more tenants in your life, correct?
Correct.
So therefore, you want to occupy the whole property.
We've done it already once with that. We did an Ellis Act about 8 years ago.
Okay, but right now you want to occupy the entire unit yourself. You're not going to take in another boarder.
No,
Good. So then we're going to evict her on the basis that the owner wants to move into that unit.
that's why we told her that she was evicted. We told over 60 days ago, we told her that
Well,
my sister
telling her
needed to
that
move in.
and following the law is 2 different things. There's a procedure that we needed to go through with the city. So anyway, I don't think you're in bad shape. You are going to have to pay her relocation, which in my mind will probably be only 1 month's rent. And the $650 she can, I don't know, stick it someplace, but certainly she's not going to stick it to you. So give me a call at the office, Stacy, but I'll tell you one thing. There's no reason to worry. You can sleep well tonight. And there's only one time when you actually have to be very, very concerned. Do you know when that is? When I tell you. Otherwise, sleep peacefully. Anyway, thank you very much. Good question. And we are going to move on to, I think, a client of mine, Richard Klug. Say hello.
Hi, can you hear me?
Yes.
Hi, well, COVID's over and now it's time to collect from 2 tenants that didn't pay for the last year. One of them still in the building. He owes me $22,000. I've sent him an invoice, and if he doesn't pay or make a payment plan, I plan to go to small claims court. And my question is, what do I bring to small claims court?
Okay, first of all, the rent that's owed to you is not current rent. It's rent owed from the COVID period.
It is from the period, I think March first
2020?
to 23. No, first 2020, 2022 to 2023, I think.
Yeah, that's during the COVID period for the city of Los Angeles, at least up until, I can't even think anymore, probably through February. So
Right.
go to small claims court, just show your whatever rental records that you keep. You're going to declare that that rent is COVID. You might lose 1 month's rent out of the deal and sue him in small claims court. But but right now his rent is current. He's currently paying his rent.
Yeah, no, not a bad guy. Wouldn't mind if he stays. I have one that skipped out. How do I find her?
Well, do you know where they work?
No.
As a special, I think you are a client of mine. If you call me up and they've been out for like about 5-6 months, if they've established credit wherever they move to, I can generally locate them and the charge would be nothing. So call me at the office and I'll do a quick lookup for you. I'll see if we can find it. But we want to wait at least 6 months because if I look it up now and he just moved like last week, it's not going to show anything.
Got it. Thank you very much.
All right, you take care, Richard. Okay, let's take a look. Where did you go, Richard? Okay, let's move on to Crystal. Crystal, I'm going to ask you to unmute yourself.
Hi, Dennis. How are you?
I am fine, thank you.
I wanted to continue from my question from last week, just to refresh. Single family home in the city of Los Angeles. It's the only unit on the lot. Tenant, you told me to go. The tenant kind of like skipped out and just like moved out. We never got any notice, so followed your instructions, saw that the unit was abandoned. My question is in regards to how much rent I can deduct from her security deposit.
Well, as I said last week, you can certainly deduct from a security deposit at least rent from when you found out that they did vacate the unit. So you can deduct up to that point. If you're going to really follow the law closely, technically, the tenant had to give you a 30-day notice. In your case, you told me she pretended to mail you a notice. So it probably is not worth a fight. So I would just do it the day that you finally took possession of the premises. But technically under the law, since you never got a notice, then it's 30 days from when you found out that the tenant had vacated.
So if I operate under that, that means I could do all of June and then prorate to like, let's just say July 15th.
Well, if you found out, for example, on June 15th and she never sent you a letter, then technically she's liable for 30 days from when you found out.
Got you. Okay. Thank you, sir.
You have a good day. Let's move on to Kay. Kay, I'm going to ask you to unmute yourself.
Hi, Dennis. Thanks so much. I have a question regarding sort of choosing my battles. So I know you mentioned pursuing rental increases. I'm a new landlord and actually inherited the tenant. And so I'm curious about whether or not to pause on that pursuit, because ultimately I want the duplex, it's subject to RSO, to be owner occupied. So do you advise that I just pause on that and just pursue the no fault eviction, or doing that simultaneously?
I would simultaneously do that. Do the rent increase, and then you can pursue the owner moving. One has nothing to do with the other, and you don't know what's going to happen with that owner.
Right.
I don't know if the tenant, for example, is over 62 and has been there for 10 years, then they're exempt, and there's all kinds of things on it. You said this is a duplex, correct?
Right. And yeah, they would, I guess, be an eligible tenant. So not over 65, no kids, but they have been there for a few years.
But you have to take, if the duplex has the same amount of bedrooms in each unit, then you have to take the last one in as the first one out.
They don't. I want to move into their unit has less rooms.
Well, less bedrooms?
Correct.
Okay, then you're fine at that.
Okay.
Point. Yeah, but yeah, serve the rent increase notice. It'll kind of incentivize them that they have to move because they're getting a rent increase anyway.
All right. So, and what about parking as well? So it's a 3-car garage. There's also a parking, there's parking, you know, on the side as well. I'd like them to park not in the garage,
Well,
in the
I don't know
driveway.
that you'd want to do that based on your ultimate plan here, but if you only wanted them not to park there, you could serve them with a 30-day notice that you're removing their parking, but you'd have to give them a corresponding decrease in rent, which is anywhere from $70 to over $200, depending on how much street parking there is.
Okay, got it. Thank you.
All right, take care. Nellie on her iPhone. Going to ask you to unmute yourself.
Good afternoon, guys, and thank you for hosting these calls. And I really appreciate that you have those forms online because I definitely needed one recently. So thank you for that.
You're breaking up a little bit,
So
Nellie,
my
so
question, can you hear me?
I can. So maybe you better speak
Yeah.
quickly.
Okay, so my question is, my tenants have a 12-month lease that will be up soon. If my sister, a close relative, moves into my single-family home, am I obligated to give the tenants any type of relocation money?
Where is your property located?
It's in Los Angeles County, but it is a single-family home that does not fall under RSO.
You say Los Angeles County. Let's try this again. What city is your property located?
Reseda.
Okay, so Reseda is the city of Los Angeles, okay? And this was a 1-year lease?
Yes.
Okay, you're right. Your property is not subject to RSO, the rent stabilization ordinance, but it is subject to the JCO, which stands for the Just Cause Ordinance. And unless your parents own this property, or unless your sister is also an owner, a sister moving in is not a family member that's approved to move in. So we can't ask these tenants to move on the basis that you want a family member because it's not the proper family member. It can only be grandparents, parents, yourself, your spouse, domestic partner, your children and your grandchildren, and a sister is not one of them, unless you want to put her on the title.
Okay. If I had my parents move in, would I be responsible for giving the tenants any type of relocation money?
I'm not sure I heard the whole question because you broke up a little bit. You were saying that if you did have a proper family member, then you would have to pay relocation. The relocation would only be 1 month's rent. Anyway, thank you very much, Nellie. We are going to move on to Austin. Austin, I'm going to ask you to unmute yourself.
Good afternoon, Dennis.
Hello, Austin.
Can you hear me okay?
I hear you wonderfully.
All right. So I am going to be owner occupying a fourplex in the city of Long Beach, and I'm inheriting multiple tenants. One of them has been living there for 10 years, way below market rent. But what I'm concerned about is they have not, they never put in a security deposit. The other unit is in the same situation, but they are on they just moved in a few months ago. They also did not have a security deposit. They are below market, so I intend to raise both units by 8.9%. But what my question is I also want them to pay a security deposit for damages and all the other reasons why a smart landlord collects a security deposit. So the question is, can I demand a security deposit from them? And how would I do it?
Well, first of all, for everybody to know, July 1st, 2024, coming up in just a few days, the state of California has limited the landlord's right to take a security deposit that's more than 1 month's rent. So that's the first thing everybody's got to be concerned about, that any security deposit that you take effective July 1st can only be 1 month's rent. As to tenants who are already in possession, there's nothing that you can do to get more of a security deposit from them. Austin, I'd probably recommend that you do a renovation on these 2 units where the rent is low. Renovation is described as work that would render the premises uninhabitable for 30 days and requires that you obtain a building permit like an electrical or a plumbing permit. So if you were going to, let's say, for these 2 units, redo the bathroom and the kitchen, number one, you'll have a beautiful looking apartment. You'll be able to evict these tenants. The relocation is only 1 month's rent. And now you can raise it to market level and you can get yourself a big fat 1 month security deposit for the new tenants coming in. That would be my recommendation. You probably want to do the renovation on it anyway. So here's an easy way of getting your rents up to market level.
Are you suggesting that I'm not allowed to ask for any security deposit at all, or just nothing more than the current?
No,
month's-
once they're in, they're in. You can't do anything after that.
Got it. Okay.
You're done with that. That's why I think you have such a wonderful remedy by just doing the renovation, which probably needs to be done, and you'll increase the value of your property exponentially.
Yep. Thank you, Dennis.
You take care. And we are going to move on to Anna. Anna, I'm going to ask you to unmute yourself.
Hello, Dennis.
Hello, Anna. Speak right up.
Hi, I was wondering for LARSO apartments, I've had long-term tenants that are now month to month. And some of the rental agreements I've used were dated back from 2015. Is there any way I can ask some of them to sign a new updated rental agreement as long as I'm leaving them month to month?
You can ask them to sign anything. You can ask them to sign the pink slip to their cars, right? So that's not the issue, is that you can ask them. Of course you can ask them, but the tenants can kind of easily say no. And if they say no, there's nothing you can do with that.
Okay, so then what types of terms can you change if you want to change any?
Might be able to change like a due date. So maybe the rent's payable on the 5th and you want to move it back to the 1st, but there's not really much that you can change. You could take away a parking space and giving them a decrease in rent.
Okay. Okay.
You
Thank
have
you.
rent control, okay?
Yes,
You're
do.
stuck. That's what our politicians have done. They've taken away your property rights. You know, it'd be like saying that I'm going to tell you what you can sell your house for. But that's what the government is doing for anybody who's labeled as an income property owner. And as I've said before, ours is the only industry in the United States where our prices are controlled. And it's insanity, ladies and gentlemen. So make sure, though, that you do give that 4% rent increase and have it effective as of August 1st, assuming you haven't had a rent increase. Okay?
Thank you. You know what, last question is, like on those rental agreements back then, I was able to charge a 6% late fee. Now, seeing your new video about that, can I still enforce what I had back then?
Yes, if you have a rental agreement signed by the tenant and the late charge provision has that proper language, as mine does on my website, if it has that type of language, then yeah, you could serve a notice to perform or quit, giving them 3 days to pay all the late charges that they owe you. If they don't pay it, then you have the right to evict. Okay? But again, you have to have the right language in your rental agreement. If it's there, then you're golden.
Okay. Thank you very much.
Okay, Anna, we are moving on. We're doing very good here. The questions have been very succinct, so I appreciate that. Mark P., I'm going to ask you to unmute yourself. Mark P. Going. Mark, I think you're asleep at the wheel or you're having problems. So we're going to move on to Gus. Gus, I'm going to ask you to unmute yourself.
Hey, Dennis.
Hello.
So, let's say I have a pending UD action and I'm the plaintiff. There's already a trial date set. Now, the issue, I just noticed that on the complaint, I put that the tenant agreed to pay rent on the 1st of the month. The lease actually is for the 6th of the month. Can I just amend the complaint?
Well, first of all, on the 3-day notice that you served, did it say the period was from, let's pretend, March 6th to April 5th? Did it have to?
Yeah.
Okay, so then, yeah, and the 3-day notice was attached to the complaint.
Correct.
So therefore, the complaint did say the rent was payable on the 6th. So that's not a big deal. You can just amend according to proof.
Do amend the complaint according to proof, right?
Yeah, but you do this in open court while you're
Oh,
doing
I see.
so. Yeah.
I see. Okay, perfect. All right, appreciate it. Thank you.
All right. Take care. Let's go to Janice. Hello, Janice. Are you there, Janice?
Hi,
Hello.
thanks so much for doing your weekly landlord therapy. You have no idea.
How's the weather in New York today? Because it's hot here.
It's, believe it or not, it's beautiful today. Today only.
That's excellent.
Anyway, I'm still trying to wrap my head around the long-term repercussions for single-family property owners of 567. Should I decide to take the option of moving back in for a year within 3 months? What happens if I change my mind after a year? Does I just get put back in the same loop?
Yeah, you'd have to offer the unit to the tenant at the same rate as what he was paying.
Okay, can I do a renovation and move in at the same time? And
Well, if you're going to do a renovation, that's much cleaner. So I wouldn't waste my
Yeah.
time saying you're going to move in, because this way, once you do the renovation, you don't have to move in. So why put more onerous on yourself? So renovation, they're going to get rid of renovation. They've already tightened it up. It used to be that you just had to declare that you were going to
right,
do work more that would take more than 30 days to complete, and that you declared that you would be getting a building permit. Now you have to get it prior to the initiation of the service of the notice. So that's just a wonderful remedy, unless you're subject to some local rent control ordinance like Los Angeles, like that previous person talked about. So I like that a lot.
so is this being challenged in California? It is, similar laws in New York are being challenged again to the
Yeah,
Supreme.
but as you can tell from the Supreme Court on the last one that was brought up, it didn't go anywhere. So I think the Supreme Court was reticent after the issue dealing with abortion to come up with something controversially on that. That was my opinion, because I don't see any basis of that man cannot contract with another man, and how the government is putting their hands in this pocket for this industry only. I don't get it, but God only knows. Okay, thank you very much. I'm going to give Mark one more chance. Hopefully you figured it out. Mark P, can you unmute yourself? And the answer is Mark is asleep at the wheel. So we are, oh, there you
Yes,
go.
sir. Hi, thank you, Dennis.
Hey, you got it.
Yeah, just in your intro, I noticed you mentioned no 60-day notice, but for Section 8 tenants, the Housing Authority does require 60 days at least to provide to the tenant. And then I just wanted to get your take on, I think you
Well,
mentioned.
let me slow
Go
you
ahead.
down on that one. For Section 8, as you well know, Mark, we do not determine rent increases. It's Section 8. You have to ask them, and then they give you the rent increase. So it's not like we can say, gee, we want to go up on the rent. It's Section 8 determines what that rent increase is. But go ahead with your other
Yes,
question.
correct. Much to our frustration. They are exempt from Section 8, so you can actually request more than what's allowable under 1482.
Yes, Section 8 is exempt from 1482 statewide rent control, so they could give you whatever they want, but and you have to show them the comps as to what that is, okay? And then where is the property located?
City of Gardena.
Okay, so Gardena doesn't have any rent control except for statewide rent control, but you're exempt from statewide rent control because it is either a condo or a single family home, correct?
No, this would be an apartment.
Oh, well, then you're stuck. You've
Okay.
got to only deal with what they're stating. You could, if they wouldn't give you any rent increase, we know that it's going to be 8.9%. So if you could cancel Section 8 by serving a 90-day notice, canceling the Section 8 contract for economic reasons, and then tell the tenant, if you want to stay, you got to pay the rent plus 8.9%. That would have the effect of getting rid of the tenant. That's a very hybrid way of ridding yourself of this tenant and trying to get more rent. Because obviously, if you terminate the Section 8 contract, the tenant's going to have to pay the full amount of rent. And most people don't know that under Section 8, it is a ground to evict the tenant or evict to terminate Section 8 on the basis that for economic reasons. So Mr. Section 8, you won't give me a rent increase. I've shown you the comps here. So guess what? In 90 days, I'm done with you. Then that means the tenant has to stay and pay the rent, the full rent plus 8.9%. So that would be a way of ridding yourself of the tenant.
Thank you, Dennis. Much appreciated.
Okay, you take care, Mark. Okay, let's move on to, I see iPhone CXM. I'm going to ask you to unmute yourself. *6 if you're really on an iPhone. You're on an iPhone, *6. Otherwise, I'm going to ask you to just hit the unmute button. And okay, we will move along. Freddie G. Freddie G, I'm going to ask you to unmute yourself.
Hey, Dennis, first time, long time.
Hey, thank you.
I have a tenant that pays rent late every month with the late fee. At what point is that grounds for eviction?
What city, please?
It's in East LA.
So East LA, you're under the unincorporated area of LA County?
Yeah.
So you got like a 9002 or 9022 zip code?
22.
Yeah. So that's not going to be grounds. If they pay the late fee and they pay the rent, you've got to catch them where, if, for example, assuming you're above the threshold, how much is the rent per month?
2,000.
How many bedrooms? It doesn't matter.
2.
Okay, so he'd have to be 2 months late, because under the threshold, which you're subject to in unincorporated area for a 2-bedroom unit, it's 2544. So the 3-day notice has to have more than 2544. So if every month he just comes to you with the rent plus the late charge, you'd have to accept it at that point. But if you ever got to a point where he didn't pay the rent for, let's say, for the whole month of June, then on July 2nd, we could hit him with a 3-day notice for 2 months, and now you'd be above the threshold.
Okay.
All right.
Thank you.
Thank you very much.
All right, Dennis. Thank you.
Eric, I'm going to ask you to unmute yourself.
Hi, Dennis. I have a 4-unit in Glendale, California, and I'm considering doing a owner-occupied move-in. My question is, does LA County have their own set of rules that I have to adhere to? Because I know Glendale does, but I've been hearing about how you have to hire like a consulting firm to help them find a place and things like that. I'm just kind of confused.
Well, luckily for you, your property is in Glendale, and it is it's more than 3 units. That means you are 3 or more units, so you're subject to the Glendale ordinance, and you don't have to do any what they call relocation specialists, as they do for unincorporated areas of LA County. Glendale is a city, so you don't have to worry about LA County poking their nose into your business, because Glendale is its own city. So you just have to comply with the Glendale statute, which I don't have it off the top of my head, but I think the relocation is about 8 times the monthly rent or something to that effect. But you certainly can move into your own unit.
Excellent. Thank you so much.
Okay, Eric. And Art, I'm going to ask you to unmute yourself.
Hey, Dennis, thanks a lot for this forum. There ain't a lot of help out there for landlords. I'm telling you that right now. So, first of all,
I've noticed that, by the way. And you know what? While we're on that subject, as much as I enjoy doing this, one of the other reasons I do this, and trust me, it's not for pecuniary interest, it's that, you know, I've been blessed with my law practice, and this is, for me, a way of giving back to the landlord community that is so desperately in need of this type of information. So really, it's my pleasure to do this for you guys.
Awesome. That is awesome. So, okay, so I'm going to filed a 3-day notice. I want to use one of your forms, but it has your information on it. Do I have to wipe that out, or is that going to be a problem if you weren't if I weren't represented by you?
No, that's just a form. It would be like, I don't know if you've ever remembered the old Wilcott forms, or maybe some forms say California Association of Realtors. It doesn't mean that they're doing it. So you can keep my name on that notice, or you can white it out if you feel more comfortable, but it doesn't make any difference. It's we encourage people to leave my name on it. So therefore, when the tenant doesn't pay, you can call us. But again, it has no legal effect one way or the other.
Okay, so my question is, my current, I actually raised my rent about, I don't know, 2 months ago, and I noticed that it has the date of the rental, the date of the agreement missing. I'd like to void that and just let my tenant know, hey, listen, I made an error. I'd like to void that, and then I'll serve you with.
Has the tenant started paying that increase in rent?
No, not at all. She's behind 3 months. I'm going to evict her.
Okay.
But,
yes. So I don't even know why we're talking about increasing rent. If you've
well, the problem was I served her that notice to increase the rent before she stopped paying rent.
Okay,
So
okay,
should I just
that's
leave it
fine,
alone?
but right now, I think it's irrelevant with the rent increase. The tenant owes you rent. You know, I don't know why people have tenants except to get rent. So the worst thing a tenant can do to you, other than burning down the place, is not to pay the rent, because that's the whole reason why they're there. So what you need to do is forget this rent increase notice, head on over and fill out a 3-day notice, and then call me. What city is your property located in?
I'm in Los Angeles, 90043.
Okay, so you would need to send a copy of that notice into the city with their eviction cover sheet. I have that as on my website. Also, there's some notices that need to be posted in a conspicuous spot on the property, and those are also posted on my website.
Okay, when can I call you?
When should you call me?
Yeah.
Don't call me late for dinner. No.
I got voicemail when I called you. I just wondered if there's a time that you take calls from landlords.
Well, only for the people listening to this, which is now about 1,000 people a week. If you call, we're there 9 to 5, but it's better to call in the morning. Our phone number is 1-800-77-EVICT. But if you want to get me directly without any wait, and don't tell anybody, if you call that number, hit my extension. As soon as the recording comes up, which is 1001, you'll get me. But there's a big caveat, and that is you can only use that extension 1001 between the hours of 7 to 8 a.m. Monday through Friday. If you call 801 or 659, I will violently hang up the phone. So, but for that 1 hour, you can get me.
Can you repeat the number?
Well,
Okay,
it's my office number, 77-EVICT. And my extension is 1001. So call
001.
Yeah, it's Monday through Friday. As soon as a recording comes on, hit that extension and I'll pick up. Anyway, nice talking with you, Art. And by the way, everybody, that was only for Art. No, I'm kidding. If you guys want to call me and talk to me directly, I'm happy to talk to you. Steve S., I'm going to ask you to unmute yourself.
Good afternoon. Great work for the community. Thank you very much, sir. I have a older lease that has a 10% late fee. I know you spoke about that earlier. I'm not sure the correct language is in there. So a couple questions. Do we need to change the whole lease, which I know they don't have to sign? Can we do an amendment, ask them to sign it? Can we do a change of terms, or what's the best way to address?
Well, you can't do a change of terms. First of all, what city is this?
It's in Arcadia.
Okay, so Arcadia is as a city, and that is not under LA rent control.
Correct.
Is this a house or an apartment?
Apartment.
You could, well, first of all, you have to take a look at the language in your lease. Okay, 10% I don't think is a problem, but it's got to have that special language that says something to the effect that it would be impractical or extremely difficult to fix the actual damages incurred by the landlord when the tenant fails to pay the rent. It's got to have that kind of language in it. By the way, I didn't remember that. I was cheating by looking to my right. But if it has that language in it, then I don't mind that it's a 10%. But if it just says, hey, if you pay your rent and would not, don't pay it within 3 days of the due date, you owe me 10%. That's a bad provision. Can you do a change of terms of tenancy? I would say probably. You probably could do it and say, this is the new late charge provision. And maybe make it go down, not 10%, maybe make it 5% or 6%. And this way, I think it would be legal to do so.
As I'm looking at it right now, it does have those, it's extremely difficult. And what I'd like to do is screenshot that, send it to your office, pay you for a quick look at that, if that's acceptable.
And I don't have a problem with that, but if it has that language, just compare it to the one that's on my website. And if it starts with that language, I'm sure that that is a proper late charge provision. So if the tenant doesn't pay you the rent, whatever you do, don't serve a notice to pay rent or quit. Do serve a notice to perform or quit to pay that late charge. If they don't pay it within the 3 days, then you've got wonderful grounds for eviction.
So it's perform or quit.
For a late charge, and a notice to pay rent or quit is for rent, okay?
Okay. I may screenshot, send that over and send a credit card and have you review it.
Sounds good, Steve. Happy
Thank
to
you
talk
very
to you.
much.
But I probably won't charge you.
Thank you.
All right. Let's see here. Lee Stadell. Lee Stadell, I'm going to ask you to unmute yourself.
Hi, Dennis. I own a single family residence in Newport Beach. The tenant has been there for 2 years. It's on an annual lease. The tenant is a sophisticated real estate commercial broker. The lease expires at the end of the month. The issue I have is during this rain, one of the bedroom windows was just, it was a wood window was destroyed. And instead of being an easy $3,000 replacement, it's going to cost me $175,000 due to egress code. Anyway, without getting into that, the problem
That
I
sounds
have.
shocking to me. I think I want to be your contractor.
No, I've gotten 7 bids and this is the real price. Trust me. And I'm an appraiser, so I understand. Anyway, that's not the issue. The issue is, thank God the tenant is willing to stay on. The problem I have is the contractors, and this has been uniform. I mean, it's a structural engineer is involved to rip open all this stuff. It's going to take 4 months to get through the city, including the structural engineer plan and a permit approval. The work will take approximately 60 days. The tenant wants to stay on, but I believe that this could be a severe health and safety issue if they were to remain in the property during the renovation.
How many bedrooms, please?
3 bedroom, 2 bath, 2 adults living in the main bedroom, but I just don't
Where is
trust
the
them.
window, in the main bedroom?
No, it's in the secondary bedroom
So
that's
why
not
don't
being.
you just say, look, I'm gonna reduce the rent, figure out an amount, and then we're gonna permanently lock this door. So it will not affect your health because the door will always be locked unless the contractors are in there, because obviously they just need access either from outside or from the inside of that bedroom.
Yeah, it's a little more complex. So let me tell you, for uniformity, because it's in Newport Beach and it's a $2.5 million house, I have to do the living room window to conform for curb appeal. I mean, it's the appraiser in me, I guess. Anyway, so it will be uninhabitable because it's a 1945 built home that involves re-leveling of floors, removing a fireplace to open up the window opening, if you can believe this. So I want to keep.
Well, I don't know how the tenant's going to be able to stay during that. I think what you should do is tell them, look, I'll rent you temporary house. You don't pay the rent here. You pay the rent on the temporary house, and then as soon as it's done, I'll have you come back. I think that
they're willing to stay on with no. The lease expires this month with no increase in rent, which is okay with me. I don't care about money. I care about having some income because it's my only form of income right now. My question is, since I don't know when the contractor can start, and the contractors are so bloody busy here, I don't have the luxury of renewing the lease for 12 months and giving them a 60-day notice, to vacate due to 60-day rehab. I'm just
Let me
wondering
ask you something on your rental agreement. When did this rental agreement start?
2 years ago, exactly.
Is there a box checked in the rental agreement that this property is exempt from statewide rent control?
Yes, sir.
Okay, so then when is the lease over?
June 30th.
Okay, so why don't you tell the tenant, look, I need you to move out, so I'm gonna serve you with a 60-day notice that you're gonna be out by the end of August. I am going to, I know this is a hardship for you, but this is where it is. However, I promise you that if you come back, if you want to come back, I'll let you back in at the same rent. But otherwise, you have the right, based on this situation, that July 1st, you could serve a 60-day notice to get out. Then you don't have to worry about any liability issue. The only other thing that you could do would be to have them sign some sort of a waiver, but I don't know how valid that would be. You know, these attorneys just, you know, chomp through anything. So I would just tell them, look, you got to go. But I'm willing to let you come back. No harm, no foul, but we've got to do the work.
The thing is, it may take up to 9 months to get all this approved and have the work start, and I need the rent in the interim. So I want to create a win-win situation that's
Well,
fair for all.
then they'll take the other plan where you're going to get yourself an ironclad agreement that they will hold you harmless if anything happens.
No, I want them to vacate when the work is ready to start. So would you suggest I do like a 9-month lease, not knowing when that's going to be, or should I do a month-to-month lease and I have
I
to
would
give them
just do a
60 days
month-to-month
notice?
lease, so you have the option of a 60-day notice to vacate.
Could I
Any-
request the tenant in
Last
return?
question.
Yeah, could I reduce the rent in return for them giving me a 30-day notice in lieu of my 60-day notice? Is that legal?
Sure, sure. They're going to agree to move out on a certain date. Anyway, thank you very much, Lee. We are getting close. We're going to move over quickly to Alfredo Castro. I'm going to ask you to unmute yourself.
Oh, hi, sir. Pleasure. I have two quick questions about raising the rents. One, I have a townhouse in Carson that is extremely below market rent, maybe about $1,500. Now, I'd like to move my mom into the place. However, if the tenant is willing to pay market rent, I don't mind doing that. So I guess my question is, with all the political correctness and the laws, which approach do I take with this?
Very simple. Raise the rent to market level, period. Serve a 90-day notice. Do it now to take effect October 1st. That's 90 days.
Got it.
And do it prior to June 25th. So you got 10 days.
I've raised it recently $100. This is how we got to the correct.
It doesn't matter. You can raise it again.
Okay. And the second question, similar to Mr. Mark a little bit earlier, I have another townhome in Gardena that is on Section 8. Now, this is in unincorporated Gardena off Figueroa, so it's with LA City Section 8. My question.
Wait. You said it's unincorporated, or it's really part of the city of Los Angeles?
Harbor Gateway. So I guess that's part of the city of Los Angeles.
Yes.
I know I'm LA City Section 8, not LA County.
Right.
That one is, again, 3,000, but I believe for a 3-bedroom, I could get almost $4,000. My question is there a way to negotiate with Section 8 for saying,
Yeah,
hey,
you need to tell Section 8, look, this is the comps, I need a rent increase. If Section 8 says no, then we can terminate Section 8 and tell the tenant he's free to stay as long as he pays the rent increase. And I've done that, and we've been successful with that. Anyway, thank you very much. And we are going to move on to Moran. Moran, I'm going to ask you to unmute yourself.
Hi, Dennis. I have a single family home in Tarzana. It's a 5-bedroom. I leased it to a mother with 2 kids, but I found out that she never lived there. Her mother was paying the rent. And starting June, when I told her that, I'm not going to renew.
Well, who's living there? Just the 2 kids?
No, the kids and the grandma. That's what
kids and grandma are living there, and who's paying the rent? The mother?
Yes.
Okay, and what's the issue?
So the issue is that when I told her that I'm not going to renew the lease, and then she hasn't paid the June yet. And
well, if she hasn't paid the June yet, I mean, that's the only thing you need to talk about. Serve a 3-day notice for the June's rent. I presume, how many bedrooms?
5.
Oh, 5. Oh my God. So it's got to be above. It's let's take a look here. Fair market value. What's 15% above 3,600? So somebody out there figure that one out for me. It's about 360 plus 180. That's 540. How much is the rent per month?
6,500.
So, okay, you're fine. So if they're not paying you the rent, don't even think about anything else. The only reason you have a tenant there is to get rent. So renewing, not renewing, they're not paying you. Today is the 15th. Where's my damn rent? So I would serve a 3-day notice, and then I would proceed forward with the eviction.
How about the late payment?
You can also serve a notice to perform or quit for the late payment.
Yeah, she hasn't paid for 2 months, starting the first month. 2 months she's late. She's been late.
Yeah,
So
you might want to call the office, but otherwise you can serve a 3-day notice. That's the only thing you need to talk
Another
about.
question,
I mean, it's kind of like, I hear this all the time. You know, you got a guy who is suffering a heart attack and he has a hangnail, and we're talking about the hangnail. You know what I mean? The guy's got a heart attack. That's the reason why you have tenants. Anyway, thank you very much. I appreciate that. Even though we are 1 minute over, I am going to do one more because it sounds interesting here. And that is the Velez team. You snuck in after hours. How can I help you?
Hi, thank you so much, Dennis. I have a client, I'm a realtor, I have a client who plans on moving back into the property. This is on a 12-month lease. Property is in Reseda. And it, does that require 1 month?
Okay, so this is the tenants there on a 1-year lease. It's a single family home?
Yes, single family home.
And it's a 1-year lease?
Correct.
Okay,
It's
so
about
yes,
to
there
be
would be,
open.
the relocation would be 1 month's rent.
1 month. Okay. And give me 1 second.
1 second. We're
I'm sorry.
live to
There was
thousands of
another.
people.
Okay. I think that was
That's pretty good.
it.
Anyway, love you. And ladies and gentlemen, we have made it past for another wonderful edition of Zoom Landlord Tenant Radio. I appreciate everybody who participated today and who watched on YouTube Live. We're going to do this again next week. So please tune in. And I want everybody, once again, I wish all the fathers out there a happy Father's Day. And thank you very much, everybody.